Anybody?
Is Mr. Ragnan in the waiting room, Your Honor?
Oh, no, he isn't.
Can we go to another person,
Sure.
please? That's where we're.
Sure.
Thank you.
Sure. Mr. Davis, is your client's name Mr. Spraggins? No, it's Mr.
Godspeed.
Is that you, sir? Step up, please.
This part right here.
All right, Mr. Godspeed is in person in the courtroom. State your name for the record, sir. Speak up.
Kenneth Goodspeed.
Kenneth Goodspeed.
Yes.
This is called in case number 250-55-11901. People State of Michigan versus Kenneth Goodspeed. Appearances, please.
And for Douglas for the people, P72748.
And Maurice Davis, P76203, appearing with Mr. Goodspeed. I'll wait for Marie to please stand mute.
Court order not guilty plea on behalf of Mr. Goodspeed. Bond recommendation from the people.
Your Honor, given the allegations that people are going to ask for $100,000 personal bond, Your Honor, we would ask for the following conditions: that Mr. Goodspeed not enter into any real estate transactions without prior approval of the court, and that Mr. Goodspeed not record any real estate documents without prior approval of the court. Besides that, we have no objection to $100,000 personal.
Judge, I'm asking for a personal bond as well. I would ask for $10,000 personal. Client doesn't have any prior felony history. He's here. He walked in. He contacted my office after being made aware of this warrant. And this is the first condition that the prosecutor was requesting.
The first condition was no real estate transactions without prior approval of the court.
No real estate transactions. Yeah, he's a real estate investor. So that could hamper his career. So I'd ask the court not to impose that. I mean, I don't have the discovery, but if there's a specific property that they're alleging, then I would ask for a bond recommendation. Well, I would ask for a bond condition with respect to that particular property, not a general no real estate transactions, because of the nature of my client's work.
Well, Mr. Davis, just a point of, hold on, Ms. Douglas. Mr.
Yes.
Davis, you said he does real estate. Can you clarify?
He's a
What do
real
you mean
estate
by that?
investor. So he purchases homes. He owns a car lot. So there are a lot of things that he may need to do while this case is pending. That bond condition would hamper his business and his career. So if there's something that can be tailored
Is he
more-
in the middle, to the best of your knowledge, is he in the middle of conducting any real estate transactions as we speak, to your knowledge?
I'm not sure. I can't say for sure if he's in the middle of, but that's what he does for a living.
Okay. Ms. Douglas?
My response would be, I didn't ask for no transactions whatsoever. I said without prior permission of the court. And Your Honor, if this involves legitimate real estate transactions, then surely his attorney could show the court, say, for example, title search or something like that, to show that it's a legitimate deal. He's specifically accused of committing real estate fraud. If he was accused of, say, doing securities fraud, he wouldn't be allowed to trade securities while his case is pending. He's accused of forging multiple documents, including a court document that purportedly was to have been signed by the chief judge of the county. And so, Your Honor, we are asking for that. No transactions without prior approval of the court. I'm not saying no transactions at all. I'm saying without prior approval of the court.
And what was the second condition, Ms. Douglas, again?
No recording of real estate documents without prior approval of the court.
All right, your response, Mr. Davis, to both of those. The second one?
I'll rest on my arguments, Judge.
Did we lose the DDC?
Well, Mr. Goodspeed's in person.
Oh, I'm sorry.
And I put the gentleman at DDC because I wasn't talking to him right now. That's why I put him in the waiting room. You didn't lose him. I put him away. for the time being. But to your argument, to both council's argument, what I was initially considering was a moratorium on any real estate transactions. Period. And I think Ms. Douglas was a little bit more generous in terms of no real estate transactions, no filing of any real estate or title paperwork unless with court approval. I think that's a little bit more generous than what I had inclined to do was a moratorium, at least until the preliminary examination. So, Mr. Davis, what is your preference? Would you want a moratorium until at least the preliminary examination, or no real estate transactions approved by the court? Or do you have a preference?
By the court, those are our two options.
Okay. No real estate transactions. Unless approved by court. And two, what was the wording you used, Ms. Douglas, for the second point?
No recording of real estate documents.
No recording of real estate documents. Unless approved by court. All right, $100,000 on a personal bond. Probable cause be February 7th in front of Judge Jefferson. Preliminary examination February 14th, Valentine's Day in front of Judge Jefferson. Is there anything else either council wants to put on the record?
Nothing from the people. Thank you, Your Honor.
No, nothing else. Thank you.
Okay, Mr. Goodspeed, wait in the courtroom for your paperwork. Okay, Mr. Ragnar, good afternoon.
Honor, good afternoon, Your Honor.
We missed you.
You know, my apologies, Your Honor. I just had to take care of something for a second, but I'm here and ready to go. Always
I
excited.
know you're here, fired up, ready to go. Mr. Gibbs, state your name for the record again.
Jerry Gibbs.
All right, this is case number 250-55-52001. Pearson Michigan versus Jerry Gibbs. Appearances, please.
Samuel A. Ragnan, P23 157 on behalf of the people. Good afternoon, Magistrate Burton and Magistrate Burton.
Good afternoon.
Reagan.
Good afternoon, Your Honor. May it please the court. Reagan P57156 on behalf of Mr. Jerry Gibbs. We waive the formal reading and the timestamp usually has been advised of his rights.
Okay, I'm so used to being on Zoom. This is a rare treat.
You caught me because I was just coming in to call me.
Well, yeah, you caught you slipping is what I did, right? Okay, the court will not guilty plea on behalf of your client. Bond recommendation from the people.
People are asking for a remand, Your Honor. Very disgusting case to allegedly do what this defendant is alleged to have done to a 13-year-old girl and a 14-year-old girl. He was the boyfriend of the victim's mother. She would go to work on Saturdays, and most of these incidents happened while she was at work, and the 13-year-old girl was staying with the defendant. He has rubbed her breasts over her clothing multiple times and under her shirt as well. He's performed cunnilingus on her on 2 different occasions. First when she was 13, the last time when she was 14, just after her birthday at one point. So, Your Honor, I just think it's absolutely disgusting. I don't think I think a remand is definitely necessary. He's got an assault with a dangerous weapon on 5214, controlled substance delivery on 5510, and he's also got a police fleeing in third. But none of that compares to what he's allegedly done to this little girl. For the rest of her life, she'll have to put up with this.
Okay. Reagan?
So Judge, what we do is we have this thing called a trial, it's a process. This is just your arraignment. We're not deciding whether he's to be guilty today or anything of that nature.
Okay.
Just go through the process. Today is just your arraignment, Judge.
Correct.
Obviously, my client denies every allegation in here. He says it's all lies. He'll have his day in court. This is from 2022. Right? They didn't sign the warrant until yesterday, or a couple days ago, Judge, almost 3 years later. And I'm not trying to make light of the allegations at all. Don't get me wrong. These are very serious allegations. But right now, that's all they are. This thing will play out in court. He'll have his day in court. But today, he's not going to have contact with this person. I'm asking the court to release him on a personal bond, no contact. I don't think there's been anything, Judge, that has happened since the allegations have been made. And again, we're not determining guilt or innocence today. We're simply setting bond. Does he have a prior? Absolutely he does. Does he have prior? Yes, he does. Judge, he's a court. He also has congestive heart failure. He's 61 years of age, lives in the city, has lived here his entire life. They have strong ties. It's not a flight risk. I don't believe he's in danger if the court takes whatever measures the court wanted to do, whether it be tether, house, or whatever. Judge. I just think that this is the early stage. He's not going to have contact with her, and let this matter play out in court. Let him have his day in court. Let the jury decide whether or not he is guilty or innocent. Not Mr. Bragg, not the people at this time, Judge, at the rank. So I'd ask the court to release him.
Two questions, Mr. Reagan.
Yes.
Hold on, Mr. Ragnar. Two questions. Mr. Ragnar, I got a couple questions for Mr. Reagan.
Sorry, yeah.
Mr. Reagan, two questions. Is he currently employed?
Judge, he does freelance auto work. That is the answer. So freelance auto work is the answer.
So he's a mechanic?
He is a mechanic. That is correct.
Okay. Secondarily, do they still reside in the household, same household?
Judge, he does not reside in the same household at all. He no longer lives in that household. He no longer has any reason to go to that household. It's been over a year, Judge, since he's actually not been there. So there's no reason for him to come anywhere near this complaint witness at all.
And we're talking about the Tracy Street address?
That is correct, Judge.
Does he still live there?
Judge, it's my understanding that he moved out. I'm sorry, Judge. I apologize. Let me rephrase.
Okay.
My client lives at Tracy. The complaining witness moved out over a year ago.
Okay.
I gotta read my notes. I apologize if I misspoke. He lives at Tracy. The complaining witness does not. She moved out over a year ago. So there should be no reason for him to come in any contact, way, shape, or form with the complaining witness.
Okay. Okay, good now, Mr. Ragnar, briefly.
Well, thank you, Your Honor. I just want to make sure the record's clear that the last incident was April 14th, 2024, when he walked in her bedroom with his penis out at that time. There's also back on February 5th of 2024, when he would rubbing her breast. But this child saying that he's kissed her coochie, meaning her vagina, on two different occasions.
Okay.
Judge, I'm not saying that the allegations in the reporting are horrendous. I'm just saying that they're allegations. Mr. Ragnar is reading on paper. I understand it. You read the same paper I read, Judge. I understand what the allegations are. Doesn't make it true.
Okay. All right. Court haven't heard argument as to bond. Unlike the earlier criminal sexual conduct cases we had in the first degree, which the dates of offense were, I think we had one this morning 25 years ago and, a decade or so ago. This is fairly recent. I mean, we're talking the most recent incident was within the past few months or even the past year. And the allegations as read in the report are horrendous. And they're ongoing, they're ongoing for at least, the allegations are for at least 2 years, approximately 2 years. And as Mr. Ragnar said, they are horrendous. He's asked for a remand on the MCR 6.106. And because the offenses are of a recent nature, they're not, within the past year or so, past year or 2 years, and it's not been a long-standing wait for to bring charges, I am going to remand Mr. Gibbs in the custody of Wayne County Jail while his case is pending. I believe given the recent age of these alleged incidents, I think the presumption of guilt is kind of relatively high in this matter. And like I said, these are really, really, really fresh and less than a year old. And so, the memory of the complainant witness won't be too bad. Like I said, unlike a case we had this morning where the incident occurred 25 years ago, and a remand was requested, I gave a cash bond because of the age of the case and other little mitigating factors. But not here. He'll be remanded to custody of Wayne County Jail.
Thank you,
No
Your Honor.
contact with Kate. No contact with Cadence Jones. Probable cause February 6th. Preliminary examination February 13th, 1:45 p.m. in front of Judge Jarkay. Is there anything else either counsel wants to put on the paper
Nothing further.
on the record?
Nothing.
Judge, so
Thank you.
just my point is kind of what you just said, Judge, and what you just laid out. You talked about allegations.
Are you arguing, or is something you want to put on the record?
I'll put it on the record.
Okay.
And something that, the allegations are in the report horrendous, but it's one side of the story.
Right.
My client tells a completely different side.
Which I expect him to.
Judge, and I think Raymond is a little different. I heard your recitation of why you think he needs to be remanded, and I think a lot of it is based on what you hear in this document and what you read in this document
Okay.
about it being one-sided. So I mean, Judge.
So what is your objection?
My objection is to a remand, Judge. I would ask for some type of nominal bond. They just signed it the other day, Judge.
Yeah, and like I said, when I point out a similar criminal sexual conduct first degree case in the morning, those allegations, the one we have for 25 years, the people asked for a remand, and I didn't feel because of the age of the case, I did not give a remand. I gave a cash bond. In this case, distinguishing this one from the prior one, these are fairly recent allegations. The complaining witness's memory is going to be relatively fresh, and and for that reason, I am giving a remand in the custody of Wayne County Jail.
Just let her testify.
Okay. Yes, let us. That concludes this hearing, Mr. Reagan.
Thank you.
Okay. Step aside, Mr. Gibbs. State your name slowly, sir.
Billy Stokes.
Mr. Stokes. Good afternoon, Mr. Stokes. You have some traffic matters in which you failed to appear in court for. As a result of your failure to appear, warrants for arrest were issued. The court's going to set aside these arrest warrants, give a personal bond in each of these misdemeanor matters that carries a maximum penalty of up to 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. You can't afford an attorney. One will be appointed on your behalf. The tickets are P1656243, disobeying lawful order of police officer, possession of drug paraphernalia, and SP 163-47261, narcotic drug-related violations. In each of these misdemeanor matters, sir, you're getting a personal bond on dollar amount. Pretrial March 7th in front of Judge Archer. Now to your main matter, calling case number 240-601-2101. People say Michigan versus Billy Stokes. Appearances, please.
Jennifer Douglas for the people, P72748.
Right on behalf of Billy Stokes, Your Honor, we waive the formal reading, stand view, he's been advised of his rights.
Okay, the court will continue not guilty plea on behalf of Mr. Stokes. As I indicated a little earlier to Mr. Reagan, we contacted Judge Taylor before we went on the record. The cash surety bond, $1,000 will continue. Bond redetermination will be February 3rd, 9 a.m. from the Chief Justice Mechanical. Probable cause February 11th. Preliminary examination February 18th. Both in front of Judge Taylor. While his case is pending, Mr. Stokes, you not to possess nor use any illegal controlled substances. Step aside, please.
Judge, so does Judge Taylor know that he capious on 1/14/25?
Yes.
In custody.
No, she doesn't.
To 1/3. So he's just.
I'm relaying to you, Judge Taylor wants this bond to continue.
Why? I mean, did she know all the facts? I mean, did she know why he missed court? That's all I'm asking her.
I don't know.
Well,
So I'm just telling you the directive. I'm just telling you the directive. She was given all the relevant information with respect to him possibly being in jail. I didn't know that, whatever. But bond continues. And Mr. Reagan, you can argue that Monday on bond determination. Step aside, Mr. Stokes.
Thank you, Your Honor.
Excuse me, Your Honor, what was that bond in the court dates?
$1,000 cash surety. And what was it, February 6th, February 13th?
February 11th, February 18th.
February 11th, February 18th. Clerk. Did you find Ms. Shaw?
We did, Judge.
Okay. She can step up. What's your name at DDC, sir? Say it slowly.
Taiwan Moses.
Okay. Okay. Ma'am, state your name for the record.
Mary Shaw.
All right, this is case number 190-458-9602. People say Michigan versus Mary Shaw. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
Right on behalf of Ms. Shaw, Your Honor, waive the phone reading stamp. She's been advised of the rights.
Okay, the court will see you're not guilty plea set by Ms. Shaw. I have a $1,000 personal bond set by Judge Baltimore. Is that your understanding?
Judge, she had posted a $100 bond to get.
When?
When did you post? January?
No. Your Honor. I'm sorry, I'll wait. I have 116.25, $100, 10% bond.
That's it, Judge, 116.
It's Capias.
116.25.
Yeah.
That's Capias bond.
Okay. I'm sorry, Mr. Reagan, what were you saying?
No, that's what I was saying, Judge. Mr. Ragnar is correct. She, 116.25 when I had when she posted the $100.
Was it a $1,000 10% bond?
Correct.
Okay, I'm gonna
Oh,
continue
100.
that bond.
I have $100, 10%. What? That's fine.
What was it?
No objection.
I had 1,000 too, but I don't know how much did you post?
I got right $100.
Okay.
$10%.
$100, $100, 10%?
Right.
No, she posted $100.
No, yeah, which means 10% of $1,000 is what?
Right.
Okay.
Oh, please don't.
Yeah.
$1,000, 10%.
Your Honor.
I will. Yes,
I just-
Mr. Ragnar.
Clarification, I'd hate to see that in there and then what I reviewed was $100, 10%. That's all I'll say. Thank you.
Okay, 1 second. Madam Clerk, can you pull the register of actions for,
Yes.
so we get clarification?
Yes.
190-458-9602. People say Michigan versus Mary Shaw. But what we have here is a failure to communicate, huh?
Well, yeah, I just didn't want it to be against her.
Oh, we're gonna find out in 2 seconds.
I may be mistaken. I don't know.
No. All right. You said, wow, we got a lot of stuff here.
One bond is open. 116.
The register of actions indicates, $100, 10%.
See, $100 paid.
Okay, well, you know what? I think I applaud Mr. Ragnar for accuracy. And I'm gonna continue the $100, 10% cash bond that she's already posted. Review date will be February 10th in front of Judge Bryant. Have a seat in the courtroom, wait for your paperwork, man.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Mr. Ragnar. What's that?
He wants to know if it's his.
Is he client here? Where? Oh, okay. Dragons, step up. My apologies, counsel. Okay, Mr. Dragon, state your name.
Joseph Sprague.
All right, this is case number 250-554-1401. Piece of Michigan versus Joseph Spraggins. Again, my apologies, counsel. Your client was kind of like in my blind spot. So please forgive me. Appearances, please.
Samuel A. Ragnan for the people, Your Honor.
Good afternoon, Your Honor. Martin Lee, doing on behalf of the plaintiff.
State your P number, please.
13202.
Okay. Wait for a reading, stand mute.
Yes, Your Honor.
All right, the court will enter not guilty plea on behalf of your client. Bond recommendation from the people.
We're asking for $50,000 personal bond. We're asking for a tether with a curfew. I'm fearful for the complaining witness's well-being. The defendant got into an argument with the complaining witness over their 6-year-old shoes, where the shoes were put. With that, he ended up, they were out, complainant was standing in the driveway behind her male friend's vehicle. He came out, racked a black handgun, and pointed it at the complaining witness, stating, "Shut the fuck up. I'm tired of Diamante getting involved." The complainant and the 6-year-old daughter, this is in front of the child, and left in the Diamante's vehicle. He has CPL license, I understand from the report, Your Honor, but to treat someone like that, pointing a gun at him when she's in fear for her life, but in doing it also in front of a child, I think is a dangerous situation. And I'd ask for the tether with curfew and a personal bond.
All right, counsel, there's no objection to the personal bond. Can you address the issue of tether, please?
Your Honor, my client is in a dispute with the mother of his child, and she has primary custody. And these allegations, the family.
Is this a dispute over custody?
Yes, Your Honor. Well, no, she's not asking for custody, but that may be the ultimate reason for her complaint. He's moved on with his life, his primary custody of the child, and these are allegations that were made out of spite with no credible witnesses. And I believe the court should take that into consideration. He's a law-abiding person. He works. He came in voluntarily, and he's complied with everything that he's needed to comply with. In fact, we've been here, believe it or not, since 8 in the morning.
I'm sorry, speak up.
I've been here since approximately 8:30 this morning. We thought we would get in early, and I talked to the officer, Mr. Hernandez, a couple times in the last few days in order to bring him in. He's compliant. You shouldn't have to suffer like this for unsubstantiated allegations in custody.
What does your client do for a living?
He is a truck driver with CDLA.
I can't hear him, Your Honor, though. Pardon me.
He says a truck driver, CDL driver. You have to leave the state?
Well, yes, I go to Ohio now. That's the furthest I go. And I'm
Okay.
also in Ohio every Sunday. Custody exchange for my daughter. My mom has her own weekend.
You mean another daughter?
No, same daughter. The daughter with the victim. I'm sorry.
Does the complaining witness live in Ohio?
Yes, and I drive down there every Sunday to pick her up at 5 o'clock.
Can you make alternative arrangements for that?
I have nobody else to do it but me. And she doesn't have a vehicle to come down here and drop her off.
Okay, well, while this case is pending, you may not, in order to avoid any further possible false accusations, according to the attorney, I don't want you to go anywhere in no contact with the complaining witness. And I understand you're not going to be able to see your daughter, but I think given these serious allegations, for your best interest, you can go there. Now, you can still go to Ohio for business. You're a truck driver. I'm not going to prohibit you for that. But as far as any contact, any child exchange with the complaining witness, I think while this case is pending in the best interest of all the parties, you have no contact. Yes, sir.
Yes, I'm sorry. Could my mother or my wife?
Yes. Anybody but you.
Okay.
Anybody but you.
Yes.
Okay. That's why I said no contact. Mr. Ragnan, any questions, or did you hear anything? Did you hear everything?
I heard pretty much, Your Honor. That's fine.
Okay. All right. Court haven't heard argument as to bond. Counsel, I am going to give your client the benefit of the doubt for the following reasons and not give him a tether and give him a personal bond. One, he's a CPL holder, at least at the time of this incident. which means he has no criminal history. Two, based on representations from your client, I take him at his word that the complaining witness lives in Ohio and that the child exchange will be done in Ohio. A condition of bond will be that he cannot have any contact with Miss Adams. So his mother or another relative, if they want to do a child exchange, would have to do that. He may travel to Ohio for business purposes since he's a truck driver. I will allow that. Also, while this case is pending, you're not to possess any handguns, firearms, other dangerous weapons. Is that clear, sir?
Yes, Your Honor.
Okay. And how many children do you have in common with the complaining witness?
Just one.
Just one? How old is he or she?
He said.
She's 7? Okay. Probable cause will be February 6th in front of Judge Jacquet. Preliminary examination February 12th in front of Judge Jacquet. Is there anything else either counsel wants to put on the record?
That was good.
I'm sorry, hold on, Mr. Counsel. Mr. Ragnar, it's $50,000 personal bond.
Thank you.
Yes, counsel?
Yes, I have Supreme Court due February 6th. Would be any other date after that?
Well, I don't have authority to change dates. You'll have to call Judge Jacquet's courtroom to change the date for that. I don't have no authority to change the dates.
Thank you.
Okay. Anything else?
No, Your Honor.
Okay. Just have a seat, wait for your paperwork.
Thank you.
Okay.
Thank you, yeah.
Okay. And you're Mr. Moses, is that correct?
Yes, sir.
All right. This is case number 250-555-7301. People say Michigan versus Taiwan. Moses. Appearances, please.
Lisa Coyle, appearing on behalf of the people.
Right, on behalf of Mr. Moses, Your Honor, waive the reading standing and advise the question.
The court will a not guilty plea on behalf of Mr. Moses. Bond recommendation from the people.
Your Honor, in this matter, the people are requesting a $15,000 cash surety tether house arrest. And for the following reasons, Your Honor, it appears that he is on height of probation out of the 16th Circuit Court for fleeing and elude, third, and attempt resisting and obstructing. He was sentenced, it looks like March 20th, 24. Since it's FIDA, I cannot see it on the public access. But I do note that in this case, I note that it's Detroit Homicide Task Force executing a search warrant on his home. They go to the home, and as you can read, that he admits to throwing the guns out of the house. He admitted throwing the Glock out the window. He admits the AR in the room is his. He admits buying the guns off the street, and he knew what the switch was for, making it fully automatic, Your Honor. Based on the fact that he's on a probation, the fact that this is Homicide Task Force, they're looking for something specific. Obviously, they locate guns. It doesn't take a lot to make me figure that these may be guns involved in a homicide. There may be obviously some sort of case involving Mr. Moses that his house was the target. So I'm asking, based on that, Your Honor, for that $15,000 cash surety tether house arrest.
Mr. Reagan?
That's always convenient when police put in reports that someone confessed, someone said, I did this, I own this, I threw this out, and Judge, I just think that, we're at an early stage now. I think counsel's gonna look at that, eat that, maybe get that statement. If it was a statement thrown out, Judge, I don't even know if it was a statement, but I do know that he allegedly possessed items that the reason why he's being charged right now for possession of these guns, Judge, there's nothing to show that, I guess, any house or any kind of type of crime was actually committed outside of possession. He's 20 years of age, Judge. He works.
What does he do for a living?
Works at Mike's grocery store, Judge. He does that and cuts grass with his uncle as well.
Okay.
So he lives with his uncle, Judge, in the city. So he has ties. As Ms. Coyle said, I don't know if he's on a probation status. That means he's being monitored. So, I don't think he's a polite risk, Judge. If you tell him not to have firearms, if you tell him don't do that, allegedly that's what the case is about. I think he would abide by that. So I'm asking for respect, full personal no contact.
Okay, Mr. Reagan, I just got a question for you. He's 20 years old. He's not even old enough to have a CPL license. And I don't know of too many 20-year-old gentlemen that live by themselves.
But this was his uncle, Judge.
He lives with his uncle?
That's correct.
How old is his uncle?
I don't know how old his uncle is, Judge, but that's who he resides with, to my knowledge. That's who he works with as well at times, Judge. That's him and his uncle. His uncle, very weak, possibly have guns, I don't know, who does.
That's the only thing that's giving me a moment of pause. The possible adults that also may live there. And unless they were found in his room or whatever, it's been a minute since I reviewed this.
Yeah, Judge.
They
I'm
were,
sorry, go ahead, Mrs. Cole.
yeah, they were.
Okay.
If I recall that he was throwing them out the window into the yard. If I can pull that part back up.
No, I'm looking at it at the third page now.
Yeah,
It's been a minute. Yeah. All right.
I think there was, I need to go find through it to myself.
Yeah.
I want to say there was proof of residency in there as well, because well, here's where I see,
No, he allegedly, it was what Mr. Reagan was referring to. He allegedly, admitted that he purchased the firearms. So
right, and then there
allegedly.
was unfired bullets located in the dresser in his bedroom, 2 unfired rounds located on the floor in his bedroom, a box of unfired Winchester rounds located in the garbage box in his bedroom.
Okay. Mr. Reagan, does he have an alternative place to stay?
Absolutely, Judge.
And where would that be?
Mr. Moses, where else would you stay? Other than his house?
Sorry?
My mom's house.
Okay.
I see that he does admit that is his bedroom, that the pit where the
Right.
pistol was found is his bedroom, so.
No, I got Mr. Reagan, point taken. Point taken. I am going to give him a $50,000 personal bond, but I am going to fit him with a GPS tether. He cannot go back to the Guilford address. GPS tether, 9 p.m. to 6 a.m. curfew. So that shouldn't interfere with his working. But I don't want him back at the Guilford address. Probable cause will be February 7th, preliminary examination February 14th in front of Judge Jefferson. It goes without saying, Mr. Moses, while his case is pending, you're not possessing handguns, firearms, other dangerous weapons. Step aside, please.
Thank you.
Jalen Yates.
Jalen Yates.
Yes, sir. Yes, Your Honor.
How are you?
I could be better.
So could I. All right, this is case number 250-555-7401. Police of Michigan versus Jalen Yates. Appearances, please.
Samuel A. Reagan for the people, Your Honor.
On behalf of Jalen Yates, Your Honor, waive the reading stand duties, been advised of his rights.
Court order not guilty plea on behalf of Mr. Yates. My recommendation from the people.
People are asking for $5,000 personal bond for the defendant. He has no priors, Your Honor.
$5,000 personal bond. Mr. Yates, while his case is pending, you're not possessing handguns, firearms, other dangerous weapons. Is that clear, sir?
Yes, Your Honor.
Probable cause, February 6th in front of Judge Marlena Taylor. Preliminary examination, February 13th in front of Judge Taylor. Step aside, please.
Your Honor, could I ask you about the Kemp case, if we're going to be doing that today, if you know?
No, tomorrow morning.
Okay, thank you, Your Honor.
Okay. No, hold on one second. Okay, here you go. What's your name, sir? I'm sorry? Okay. This is case number 250-555-7101, Pearson, Michigan versus Devin Pettis. Appearances, please.
Jennifer Douglas for the people, P72748.
Right on behalf of Mr. Pettis, Your Honor, waiver to stand he's been advised of his rights.
Court of not guilty plea on behalf of Mr. Pettis. Bond recommendation from the people.
Your Honor, the people were asking for a remand pursuant to MCR 6.106. Your Honor, as Mr. Pettis is charged with multiple counts, but 2 of them are CSC first degree, which would make him eligible for remand. Here we think there's a danger to the public. This is a situation involving someone who had known him for at least a couple years, Your Honor. And there's alleged that there was a weapon used in this assault, that when the complaining witness would not agree to have sex with him, that he then picked up a weapon, which intimidated that witness into complying. Your Honor, at this time, we have concerns given that this is somebody he knew and could identify him, and yet he allegedly still did it. But then also, this person was a minor at the time this happened, which I believe in the investigation report, it does indicate that.
Yeah, I said they know each other since she was in the 9th grade. That's what the investigation report says.
I didn't notice the part about what grade she was in.
Yeah, complainant has known the defendant since she was in the 9th grade. Okay, go ahead.
So, Your Honor, I have concerns for the public because of this, and this complaining witness in particular. There was a CODIS hit matching up with Mr. Pettis, according to the investigator's report, and so we are asking for a remand in this matter. We believe there's a high likelihood of conviction given a CODIS hit, and that there's positive ID here.
Okay, Mr. Reagan.
And Judge, maybe I'm wrong. I have the complaint being 18 years of age. So
she was, I think she turned 18 when this, by the time this was submitted in 2023, but she wasn't.
Yeah, but the next to last sentence, the complainant has known the defendant since she was in the 9th grade.
They've known each other.
Right. I didn't say they had sex since she was in the 9th grade.
Oh, I thought that
no.
Said she was a minor. That's what
okay, no, I apologize for the confusion, but the report indicates they've known each other since she was in 9th grade.
They've known each other. You said,
okay.
Because my client says this was 100% consensual. He said, never had a gun whatsoever. Never pulled a gun out, never had a gun. This is 100% consensual. And, I read it. She went over there, she went to the bed. This wasn't a case where he, this is going to come down to Judge, I guess her saying, I think she said she was on her cycle at the time, and they were in the bed, and he started to kiss on her, and stuff happened after that. He says it was consensual. She's saying it's not consensual. That's going to come down to a trial fact, Judge. I don't think that this is he's a danger per se. I think this is something he says that did not happen the way it's reading in the report. So I'm asking the court. I don't think a cash bond is necessary. I don't see any other criminal history that he has. I don't see anything else that he's ever been involved with, Judge. He works as a security every day, 3 p.m. to 11 p.m. Judge, and a lot of times I don't know why it took, and I don't even want to speculate about this happened in 21 and just signed it today. That's whatever. It's always strange though, Judge, but at the end of the day, especially when you talk about somebody that knows each other. This is not a rape kit, this is not a DNA situation. This is somebody that knows.
It was a CODIS hit. Right? Was it a CODIS hit?
Yes, Your Honor.
Yeah, plus a CODIS hit.
Plus the CODIS hit.
Okay.
Please explain that to me, Judge.
What do you need? What do you need?
So you're saying that this is a CODIS?
I'm not saying anything. I'm listening to you.
Okay, I'm just asking. So this is somebody that made an allegation.
Right.
That knew this person, that happened sometime in 2021, but it's just now 2025 and it's getting signed.
Yes,
Okay.
that's the timeline I have.
Yes, sir.
Okay. All right. The court having heard argument as to bond, and I'm going to remand Mr. Pettis. And what I particularly find very, very troubling is the last two sentences in the first paragraph of the investigator's report. The complainant stated that the sexual assault occurred June 24th, 2021, 18 years old. Okay? Clearly 18 years old at the time of this alleged assault, which you claim, Mr. Reagan, was consensual. Duly noted. The next sentence says the complainant has known the defendant since she was in the 9th grade and they had consensual sex once in the past. Now, that could have been the day before, or that could have been years before. There's some ambiguity there. The complainant and the defendant are not in a dating relationship, but are friends who hang out and talk. What the court finds particularly troubling is, and it's not clear from this investigator's report, that one could imply from this report that they have been hanging out since she was in the 9th grade, a freshman in high school, which to this court's mind is at least it kind of like predatory conduct, which is reason why I want to remand him in the custody of Wayne County Jail. I'm not saying he is. I'm just saying an inference can be made to that. Facts will come out later if it's consensual. Mr. Pettis' our lawyers will bring that out as well. But looking at what I just read onto the record, an inference can be made that this was arguably some predatory conduct, and for that reason, I find that he is a danger to the community at large and to possibly young ladies at large in our community. So I'm going to remand him in the custody of Wayne County Jail under MCR 6.106. Probable cause will be February 6th in front of Judge Jacquet. Preliminary examination February 13th in front of Judge Jacquet. No contact with Nia Marie Jackson. Is there anything else you want to put on the record, Mr. Reagan?
Just briefly, and you know how much respect I have for this court, a huge amount of respect, but the inferences you just made and you just invented and just created.
I did not.
She could be a senior in high school, she could be a freshman. Not saying that's right, but you talk about, I don't understand how you get predatory conduct because.
Listen to my words, Mr. Reagan. I said an argument could be made. An argument could be made. I'm not saying it's fact. I'm not saying I'm defined as a matter of fact that it is. I said, but based on this ambiguity report I just read to the record, an argument could be made that they have been, according to them, hanging out since his ninth grade, and by her own statement in the report, they've had consensual sex once. Now, I don't know whether that could have been the day before the last instance or years before. And like I said, I don't know. It's ambiguous. And like I said, an inference could be made on that ambiguity that he has alleged in predatory conduct.
We're saying bond on inferences we talked about.
Yes, on reasonable inferences. How's that reasonable? Okay, I'm not here to argue with you. Okay, I've stated my piece. Step aside, Mr. Pettis.
Your Honor, I just wanted to say right quick, the date of birth I was going off of is the one that's in that first sentence of the first paragraph. So that's why I thought she was a minor at the time.
Right.
Because that would make her 17.
Right. Okay. Splitting hairs. Got it. Remand. Step aside. Is that Kevin Goss?
Yes, sir.
All right, Magistrate Delphia Bird is going to handle that.
Yes, good afternoon, Mr. Goss.
How you doing?
It's over. You want to sit in this big chair?
No, I'm okay.
Okay.
This is case number 25-0555-7601-FH. People of the state of Michigan versus Kenneth Leroy Goss, G-O-S-S. Also known as Kenneth Goss. Appearances, please.
Good afternoon, Lisa Coyle appearing on behalf of the people.
Your Honor, good afternoon. Bill Reagan on behalf of the Goss, waive the reading stand.
The court will enter a not guilty plea on behalf of Mr. Goss What's the people's position as it relates to bond?
Your Honor, people are asking for a 10,000 cash surety bond in the situation. In that allegedly he had pointed a handgun at Ms. Goss. Well, they were in an argument on the freeway, and that he told her that he was going to shoot her. They executed a search warrant a few days later, and they found ammunition in his bedroom. So based on that, he has what I see is an old conviction, a 1988 assault with intent RA conviction, which he went to prison for, but nothing since then as far as assaultive. So for these reasons, people believe that Mr. Goss presents a danger to the complainant in this matter. I'm asking for 10,000 cash surety, no contact.
Mr. Reagan?
Judge, my client denies pointing a gun. He says he got into an argument because he needed to get a biopsy to find out if he had cancer or not. And he left kids, and they're trying to lie on him, hit the complaining witness, so they can get him out the way, so she can be with her significant other. They can move him out. He said these are lies that have been made up. That's what he informs us, Judge. He lives in the city. He has 5 grown kids. He has 3 kids that live with him. In the city, 61 years of age, Judge, gets Social Security income. So any bond, cash bond, would be unaffordable, Judge. He got a broken hip by his wife's boyfriend, who broke his hip. He also has cancer. He says prostate problems. But I just want the court to know that his version is completely different than what the hearsay document is. So I'm asking the court respectfully to consider personal bond, no contact, obviously no possession of any guns or weapons, but no contact with the complainant.
Mr. Reagan, I have a question. I see that the parties have the same last name. What's the relationship other than having a child in common?
Judge, I don't believe that. Are you guys still married, Mr. Goss?
Yes, sir.
So they are
We're married.
And they are residing at separate
That
locations.
is correct, Judge.
Okay. Is Mr. Goss working?
Judge, he's not working right now. He's on Social Security income.
Your Honor, if he's not working and the court's going to consider a personal, I'd ask for a tether then.
And Judge, I'd ask for no tether. I don't think that a tether is necessary if you say have no contact.
Okay. Mr. Goss,
Yes.
while you're on bond, sir, you're to have no contact with Ariel Goss, your wife, and you're not to have any third party make contact with her. You are also not to possess or purchase any firearms or any other dangerous weapons. And sir, you're not to go to her home address. The court is going to set bond at $75,000 personal. Mr. Goss, or I should ask counsel Reagan,
Yes, Your Honor.
they have a child in common. What's the nature of that contact or visitation?
Thank you, Your Honor. How old are the children that you have in common? How old are they?
Children are 11, 9, and 6, and I have custody of all 3 of them.
Does she have visitation? Do you have to see her to give her visitation of the children?
We never went to court yet for that, but she's been allowed to see the kids. I just wouldn't allow her to take the kids away because drug paraphernalia and CP has been involved prior to this. That's why they're living with me.
He has all 3?
He has all 3. Judge.
Okay. The court is not going to impose a tether at this time. So bond is $75,000 personal. And Mr. Goss, you have 2 court dates. You have a probable cause conference that is scheduled for February 6th at 8:30 before Judge Sean Jacquet. That will be here in the 36th District Court. I'm sorry, that will be by Zoom. And then you have a right to a preliminary examination that's scheduled for February 12th at 8:30. That will also be with Judge Sean Jacquet, but that one will be in person. Sir, do you understand your conditions of bond and understand your court date?
Yes, ma'am. That's all.
Okay, is there anything further from the people?
Nothing further. Thank you, Magistrate.
Okay, how about you, Mr. Reagan? Anything further?
That's brilliant, I think.
Okay, thank you. We're done, Mr. Gosh, you may step away. Have a good day.
See you on the female side. Somebody talk to me. Female side. All right, thank you.
You need someone to talk to you. I am available.
Oh, can you read me an investigation report to put me to sleep, Mr. Ragnar?
Yeah, anytime. Mr. Reagan likes when I do it as well. You know, I think it was interesting that he wouldn't take me this afternoon. He was in the courtroom. That's okay. See, we had a conversation. You were not lonely anymore. It's good. I'm glad I could fill in.
Okay. Whenever everybody's around. I will tell you this, y'all keep me on my toes.
Yeah. You know what I mean? Hey, on the floor!
Get the spell, man.
Hey, on the floor!
On the floor, man, on the floor. What's up? I'm sorry. You said you want out? Okay. Okay. All right.
Is what?
$75 personal. Yeah, oh, sorry about that.
That's okay.
I don't know who put that.
Right.
No, they do have your name.
Yeah, but that's
Okay,
yeah.
straighten it out.
When they put in the data, it's gonna be under my name. Anyway.
Okay.
What happened? Where?
Yeah, put your arm in your face on them.
Don't see.
Yeah, put your arm in your face on them.
Don't see.
I know, but they gotta see you.
All right, well, I need a mask then.
Hey, Rob. No, what the judge did. You wanna go? All right, ma'am, state your name slowly, please, for the record. Ma'am,
What?
what's your name?
Hey, yeah,
What is your name?
man.
DDC, what's your name?
Her name's Danielle Beachcamp.
Want to give it to me? It's up to you.
I'll try.
Okay. Ms. Beecham, sit up straight, please.
Ms. Beecham? Ma'am, let us see your face.
I'm sick, and I'm cold.
There you go, ma'am.
Okay.
We're gonna get her mask.
What the fuck is going
Well, I'll do the tickets. You do the okay. I'll do the tickets. Okay, what's your name again, ma'am?
Beaching.
Okay, Danielle Beecham. Miss Beecham, you have some traffic matters which you failed to appear in court for. As a result of your failure to appear, warrants for your arrest were issued. The court's going to set aside those arrest warrants, give you a personal bond, and each of these misdemeanor matters that carries a maximum penalty of 93 days in jail and or a $500 fine. You have the right to remain silent. Anything you say can and will be against you. You have the right to an attorney. You can't afford an attorney. One will be appointed on behalf. Ms. Beecham, the ticket is P975507. Driver's license never required. A registered motor vehicle and ticket U688191124. Disorderly conduct. Again, personal bond, no doubt amount. Pretrial, March 7th, in front of Judge Yancey for your traffic matters. Now, Magistrate Delphine Burton calling. Well, we handle this case. This is calling case number 24044-33301. Police of Michigan versus Danielle Beecham. Go ahead, Magistrate Burton.
Yes, hi, Miss Beecham.
Mm-hmm.
Let's see your face, ma'am.
I'm sick.
Okay.
Okay, I'm sick.
Just move.
But okay. Okay. Any issues that we need to be aware of, Mr. Reagan? Related to you? She just won't.
So, we did talk to her, we advised her of her rights, we told her what the charges were and the maximum penalties. So she knows that, she acknowledged that she understood.
Okay. Okay, Miss Beecham, ma'am, you failed to appear for a pretrial, which was scheduled on 8/23 of 2024. That was before Judge Lanice Bryant. And as a result of your failure to appear, a bench warrant was issued for your arrest. Bond was set at $1,000, 10%. Of course. So, Mr. Reagan, why shouldn't the court continue that bond that was previously set?
I think that, this is a case from the 24 judge. I'd ask the court judge to set. The bond was only set at $100, judge, which I think is minimal. It wasn't set at a large cash bond case, so I'm asking the court to consider the personal bond.
Can you tell me a little bit more about your client?
Sure, Judge. She's lifelong resident of Michigan. She does have a child, Judge. She lives in the city of Detroit, so she does have ties with the city. She's not working, unfortunately, right now, Your Honor. But she does have ties. So, this is a misdemeanor, 90-day misdemeanor. Not trying to say it's not serious. But I am asking the court for ties to the community.
May we hear from the people regarding this matter?
Yes, Your Honor, thank you. There are 3 failures to appear. She has never come to a pretrial. Every time that a pretrial is scheduled, she has failed to appear. So this began in March of 24, and within that time, there's been 3, as I said, 3 failures to appear. And each time Judge Bryan sets the 1,010%. The people are asking for that bond to remain in place. if the court is going to give a personal bond, I'd be asking for a tether house arrest, or a tether at least to bring her to court. She is not being compliant today, or has been compliant to follow the court orders since March when this case began.
Okay, one moment. Let's take a brief recess. Okay, court's back in session.
Okay, Ms. Beecham. And the court is going to set $25,000 personal bond. And however, because you have failed to appear for court in the past, the court is going to have you placed on tether. During the pendency of this matter, you're not to be in possession of any weapons. You understand that, ma'am? And you're not to engage in any assaultive behavior. Okay, then you have a pretrial that's scheduled for February the 10th at 8:30, and that will be by, no, is that by Zoom?
By Zoom.
Before Judge Lanice Bryant. Ma'am, do you understand the dates that you have to appear for your tickets as well as for your misdemeanor charge of assault and battery? Is that a yes? Is that a yes?
Yeah.
Okay. All right, ma'am. Well, get well and make sure you make your court dates, okay? Anything further from you, Ms. Coyle?
Nothing further, thank you.
Okay, how about you, Ms. Reagan? Okay, thank you. All right, have a good day, Ms. Beecham.
Oh, that's mighty presumptuous of you.
Oh, he was upstairs. He thought we were finishing up.
Nothing.
Oh, these were no bond on these, right?
Yeah, that was last time. State your name, please.
Maria Arnold.
All right, this is case number 250-555-7001, Pearson, Michigan versus Tamaria Arnold. Appearances, please.
Lisa Coyle appearing on behalf of the people.
All right, court, I'm not good to be on the client. What's that? Oh, what about the tether? No restrictions. I'm sorry, where did I leave off? You say a little louder, Mr. Reagan? Okay, Mrs. Coyle. Wait for reading staff here.
Pardon?
Wait for reading. Okay, court is not good to be on behalf of Ms. Arnold. My recommendation from the people. Mr. Reagan wants a personal bond. What say you, Mrs. Coyle?
Well, she's 18, no record. This is just a traffic stop, non-assaultive. No objection to 5,000 personal, Your Honor.
All right, Mr. Reagan, $5,000 personal bond. While this case is pending, Ms. Arnold, you're not possessing handguns, firearms, other dangerous weapons. Probable cause, February 6th for the Judge Kevin Robbins. Preliminary examination, February 13th in front of Judge Giles. Step aside, have a good day. Thank you, everybody. It's the last case of the day. You all made it count.
Great evening, everyone. Thank you.
All right, you too. Thank you.